Hello, my name is Dennis DeYoung, and I am a business relations specialist here at Opportunities for Ohioans with Disabilities, and I'd like to welcome you all to the Employers ADA Handbook, Title I Overview. Today's training is the first in a series of 5 webinars, and I'm excited to be co-hosting with my colleague, Julie Wood. Now, Julie, I understand that you recently have earned a certification as an ADA coordinator. Would you like to introduce yourself? Tell us a little bit about this certification and today's presentation.
Sure, thank you, Dennis. Hi, everyone. Thank you for joining us. We're happy to have you here with us today. My name is Julie Wood, and I'm an occupational therapist. I recently became an ADA coordinator, which I will share more about that with you in a minute. And I am OOD's Worksite Accessibility Specialist. One of my roles here at the agency is to deliver educational presentations that support employers in making their workplaces diverse and inclusive of employees with disabilities. And today is our first webinar of the year. And as Dennis mentioned, it's the first of 5 in a series that addresses Title I of the Americans with Disabilities Act. But before we begin, for those of you who joined us in December for our webinar on the top 10 accessibility resolutions, we extended a voluntary challenge for you to tell us what accessibility resolution you would like to achieve in 2021. And we said we would share that with you all today. And so we have the top 3 resolutions we received to tell you about. And so here they are. In third place is expand recruiting sources to include qualified candidates with disabilities. In second place is prepare job descriptions with essential functions, which we know helps to attract qualified candidates for your open positions, including qualified candidates with disabilities. And the number 1 accessibility resolution selected is training on reasonable accommodation and disability etiquette and awareness. That is a fantastic accessibility resolution, and it's certainly one we can help you achieve. So if you are interested in training, just reach out to your local business relations specialist and ask. Also, if you were unable to attend our training in December 2020, we do have this archived on the employers page of our website.
Julie, how exciting so many of our business partners are interested in recruiting qualified candidates with disabilities and making their work sites more accessible. Okay, so before we get started, I'd like to share some available resources. If you've not been able to attend some of our live webinars in 2020 and would like to, there are archived versions available on the employers page of the OOD website. And today's training comes with the PowerPoint slides that you are viewing now, a learner's guide, and a helpful fact sheet. And if you would like to access these now, a link is posted in the Q&A section of Microsoft Teams. Just as a reminder, the information we share in these resources and during today's conversation is for educational purposes only and is not legal advice. But we do hope this information is helpful for you. We will be stopping a few times during the presentation to answer questions, so please post your questions in the Q&A box at any time so they're ready for us when we stop. Julie, I know before we begin today's webinar, you wanted to take a moment to talk about how your role as an OT and now as an ADA coordinator inform the work you do here at OOD and this webinar series.
Yes, thank you, Dennis. Before starting this webinar series on Title I of the Americans with Disabilities Act, which we refer to as the ADA, I thought it may be helpful to explain how being an occupational therapist and now also an ADA coordinator informs the services I offer as OOD's Worksite Accessibility Specialist. So in general, occupational therapists work with clients across the lifespan in a variety of settings. And our focus is always on enabling our clients' participation in those daily activities that are meaningful and purposeful to all of us and which occupy our time. And so an occupation in my world is a meaningful activity that occupies our time. And there are many examples of these occupations, such as taking care of ourselves, taking care of others and our homes, participating in leisure activities, sleeping, and also work. Work is a meaningful and purposeful activity, and so it is an occupation, and that's why you find occupational therapists working in the vocational setting, as well as many others. If you are familiar with occupational therapists, you know most often we are providing services directly with an individual in a therapeutic way through evaluations and treatments to teach or rehabilitate a skill so our clients can participate in their daily occupations. But occupational therapists also work with populations to provide education and help remove barriers that prevent individuals with disabilities from accessing programs and environments or participating in activities. So in my current role as an occupational therapist, I am working with the employer population. And this is very important work. In fact, working with employers is addressed in our practice framework, which states occupational therapists can consult with businesses regarding the work environment, regarding ergonomic modifications, and regarding compliance with the Americans with Disabilities Act. And so when you combine our medical education and training with the understanding that how we occupy our time is important, and that one way we occupy our time is through work, occupational therapists are prepared to identify the barriers that exist in the workplace that prevent people from participating in work fully, and we can provide helpful education and resources to support employers in removing these barriers. And some of these barriers include understanding how to navigate Title I of the ADA. To complement my OT background or occupational therapy background, I chose to become an ADA coordinator because I wanted to deepen my education on Title I so I could better serve our employer partners and ultimately advocate for Ohioans with disabilities. ADA coordinators are trained on Titles I and II of the ADA, but my focus is on Title I, which is the employment title. And so being an occupational therapist and now an ADA coordinator informs my role here as OOD's worksite accessibility specialist as I consult with employers on removing barriers and making workplaces accessible so all Ohioans can participate in the daily activity of work.
Thanks for explaining more about your role, Julie. So, can you answer a common question we receive? Does OOD enforce the ADA?
That's a great distinction to make right away, Dennis, and the answer is no. OOD does not enforce Title I of the ADA in any way. Title I is enforced by the Equal Employment Opportunity Commission, which is the EEOC. What OOD's role is, or my role specifically as the worksite accessibility specialist, is to provide educational resources that connect employers with the information that helps them to navigate Title I. But no, OOD doesn't enforce the law or advise employers on what to do or make decisions for employers. We are simply a resource, and a good resource, I believe.
So, Julie, you mentioned navigating Title I of the ADA, which is what our focus is during this 5-part webinar series. And we are kicking that off today with the first training, which is an overview of Title I. So, what will we discuss today?
Dennis, our goal with this training is to introduce the main concepts of Title I. Now, this 1-hour webinar is not exhaustive of all Title I components and details, but we will summarize the ADA and identify who is protected under Title I, who is a covered entity with responsibilities under Title I, and we will identify what some of those responsibilities are, and then we will conclude today with discussing the services OOD offers our employer partners in Ohio.
Well, that sounds like a great start to the series, Julie. It makes sense to start off with a summary of the Americans with Disabilities Act.
Yes, before we focus on Title I, I'd like to talk about the Americans with Disabilities Act, which again we refer to as the ADA, which is a civil rights law. So in general, civil rights laws focus on the needs and the rights of individuals and believe all individuals are entitled to equal treatment in society. Now, as opposed to other legislation, civil rights laws are fact specific which means they are more subjective than objective. And because of this, decisions made under a civil rights law are determined on a case-by-case basis. And so you'll often hear that throughout a discussion about Title I, that the answer is determined on a case-by-case basis when identifying things like reasonable accommodation and undue hardship, because the answer is based on an assessment of the facts of that specific situation. For example, one employee who is deaf may need a sign language interpreter when attending training, while another employee who is deaf may not know sign language, and the best accommodation for him is live captioning. The ADA was signed into law on July 26, 1990 by President George H.W. Bush with the purpose of prohibiting discrimination based on disability in all aspects of public life, and to ensure individuals with disabilities have the same rights and opportunities as all individuals. So to do that, the ADA does include 5 titles which address access to work, school, transportation, public places such as state and local government, and public places such as public accommodations and commercial facilities. In the PowerPoint, you'll see we have a picture of President Bush signing the ADA into law, surrounded by 4 people.
And Julie, you mentioned our focus is on Title I, which addresses employment.
That's correct, Dennis. You and I both work in OOD's Division of Employer and Innovation Services, where we provide a variety of services to support employers with sourcing qualified candidates with disabilities and making their work sites accessible. And so our work is focused on the employer and employment, which is why our focus with the ADA is on Title I. The purpose of Title I is to prohibit discrimination based on disability in all aspects of employment. What Title I does not do is guarantee results, establish quotas, or require an employer to favor or prefer an individual with a disability over an individual without a disability. It simply seeks to ensure equal access to equal employment opportunities for qualified individuals with disabilities. And it requires covered entities to provide reasonable accommodations to qualified applicants and employees with disabilities to participate in work activities unless doing so causes an undue hardship. As I mentioned earlier, Title I is regulated and enforced by the EEOC, who has published several guides to assist employers in following their responsibilities under Title I. And so we consulted that guidance to create today's training and included these in the resources section of the Learner's Guide for additional reference.
So the ADA was signed into law in 1990, and then there was an amendment made to the ADA in 2008. So what changes occurred due to this amendment?
Dennis, although the ADA law was signed in 1990, the majority of its requirements took effect in 1992. So between then and 2008, when the ADA Amendments Act was signed, the ADA law was evolving and being interpreted by the courts. So during this time, the U.S. Supreme Court handled 20 ADA cases, and 5 of these focused on the definition of disability. 4 of these cases resulted in a narrow interpretation of the definition, which resulted in limiting the rights of individuals with disabilities. And this narrow interpretation by the Supreme Court was not aligned with the intention of the ADA. So in 2008, the ADA Amendments Act was signed into law by President George W. Bush. And one of its main purposes was to broaden the ADA's definition of disability to restore the intention of Congress about how disability was to be defined under the ADA. And what Congress intended was when a case is being decided, it should mostly focus on whether a covered entity has fulfilled its obligations and whether discrimination occurred. It wasn't intended for the courts to focus extensively on whether a person has a disability. And so the amendment resulted in broader protection from discrimination based on disability. And so here in the PowerPoint, you'll see a picture of President George W. Bush signing the ADA Amendments Act, surrounded by several people.
So Julie, I understand Title I protects qualified applicants and employees with a disability from discrimination in all aspects of employment. And you mentioned the Amendments Act broaden the definition of disability. Who then is protected under Title I, and what is the definition of disability?
Dennis, the ADA's definition of a disability is a legal definition, not a medical one. And it's different from how other entities and laws define disability. So that's important to note. The definition has 3 parts, and only one part has to be met to receive protection. The first part states an individual must have a disability, which the ADA defines as a person who has a physical or mental impairment that substantially limits one or more major life activity. But the ADA also offers protection for individuals with a record of such an impairment and who are regarded as having such an impairment. The ADA also prohibits discrimination against a person based on their association with an individual with a disability.
Well, that leads me to several questions to better understand those protections and the definition. First, is there a list of diagnoses or conditions that an employer can reference to understand who would be a protected individual with a disability?
Dennis, the ADA's definition of disability is considered on a case-by-case basis and is determined by a physical or mental impairment that causes a substantial limitation of a major life activity. So no, there isn't a list per se. However, the ADA network does offer a resource with a list of conditions that should, in their words, easily be concluded to be a disability. For example, deafness, blindness, mobility impairments, and there are others. So we've included the entire list in the learner's guide.
So does the ADA or the EEOC define what is meant by substantially limits?
Dennis, because the name of a condition alone does not determine an individual has a disability, the EEOC has criteria to help determine this, which includes the nature and severity of the impairment, the duration of the impairment, and the permanent or long-term impacts of the impairment. Now, to be substantially limiting, the impairment does not need to prevent or significantly restrict the activity. The resources we referenced said the assessment of whether an impairment rises to the level of a disability is based on the impact of the condition on the individual's life and a comparison with the ability of most people in the general population. Now, the nature of some conditions do substantially limit a major life activity, and so the assessment can be done quickly and easily to make this determination, and we mentioned a few earlier, such as blindness and deafness. But other conditions create a substantial limitation for some and not others, and so may require more of an analysis, but it's still not meant to be an extensive analysis. And so I'd like to share an example from the Job Accommodation Network about the condition of cerebral palsy, which we refer to as CP. CP can restrict the ability to speak, walk, and perform manual tasks. So an individual who is experiencing a mild form of CP may have a slight limitation with speaking. And an individual who is experiencing a severe form of CP may have a substantial limitation with walking. And so both individuals have a diagnosis of CP, but only one individual meets the ADA definition of disability due to the substantial limitation with walking.
Julie, thanks for explaining why a case-by-case analysis is important. You mentioned speaking and walking, 2 examples of major life activities. Can you explain more about what the ADA says about that?
Yes, so again, the ADA defines disability as a person who has a physical or mental impairment that substantially limits one or more major life activity. A major life activity is a daily function, like speaking or walking, that is important to most people and that most people in the general population can perform with little or no difficulty. The EEOC regulations defined major life activities, and then after the Amendments Act, they further expanded the list, which helped to broaden the definition of disability. And there are two lists of examples of what is a major life activity, and neither of these lists are intended to be exhaustive. They're both included in the learner's guide. The first one includes activities like seeing and hearing, standing and lifting, learning, reading, and concentrating. And then the second list of major life activities includes what are known as major bodily functions. And so some examples of these include neurological, musculoskeletal, and cardiovascular functions. And so all of these are examples of major life activities that may be substantially limited by a physical or mental impairment.
Okay, so let's talk now about the second part of the definition of a disability. The ADA protects individuals with a record of having a disability. What does record of having a disability mean?
In this definition, the person has a history of a disability, whether or not they currently have a disability now. So for example, a person could have a history of cancer, which is cured, controlled, or in remission. So let me share how this could impact employment. Let's say an employee with a history of cancer is up for promotion and is denied the promotion because the manager is concerned if the cancer returns, the employee will not be able to perform the job's essential functions. The result is discrimination based on the employee's record of having a disability. This definition also includes individuals who have been misdiagnosed or misclassified as having a disability, which can happen when a person is classified mistakenly as having a learning disability or an intellectual disability.
And there's a third part of the definition. The ADA protects individuals who are regarded as an individual with a disability. Can you share an example of what this means?
This definition provides protection for individuals who are regarded as or perceived as having a disability based on things like fears, stereotypes, or misconceptions about a disability. The U.S. Supreme Court has said this protection is necessary, and Congress has reiterated this because the fears and myths that are associated with having a disability can be just as much of a limitation as the disability itself. Being regarded as an individual with a disability can occur in three circumstances. So the first circumstance is an individual has an impairment that does not cause a substantial limitation of a major life activity, but is perceived by others as if it does. For example, an employee has high blood pressure that is well controlled and has a physically demanding job and is able to perform the essential functions without substantial limitations. The employer fears the employee may have a heart attack because the job is physically demanding, and so reassigns the employee to a less physically demanding job. So the employer has perceived the employee as having a disability. The second circumstance is an individual has an impairment that only substantially limits a major life activity because of the attitude others have towards her. So an example of this is an employee works as an assistant manager in a retail store and has a prominent facial scar. The employee applies for the store manager position and is qualified, but the position is given to a coworker with less experience. The hiring manager chose not to give the position to the employee with the facial scar because he believed customers would be uncomfortable. And so the hiring manager perceived and treated the employee as having a disability. And then the third circumstance is an individual does not have a disability, but is regarded as having one by others. And so the example of this is an employer terminated an employee based on a rumor the employee has cancer. The employee did not have a disability, but was regarded as having one.
So Julie, you also mentioned an association provision. Can you explain that?
Yes, discrimination based on disability is not limited to individuals with disabilities. There are times when a person who has an association with an individual with a disability is the target of discrimination. And so the ADA protects people from discrimination that is based on a known association with an individual with a disability. And the intention of this is to prevent discrimination that's based on a misconception or a stereotype about how an association with an individual with a disability may impact an employee's participation at work. So an example to help us understand this is a qualified applicant applies for a job and has a child with a disability. The employer knows this and does not hire the qualified applicant because he assumes the applicant will be absent from work often to care for the child. So this applicant is protected from this type of discrimination under Title I.
Okay, so Julie, you've talked about how the ADA Amendments Act broadened the definition of disability. How does the ADA look at things like wheelchairs that a person with a disability may use to overcome the barrier?
Dennis, the ADA uses the term mitigating measures to define those items or services that an individual uses to treat or overcome a limitation that is related to the disability. And so this includes things like wheelchairs, hearing aids, medication, and therapy. Now, things like ordinary eyeglasses or contact lenses are not considered mitigating measures. What the Amendments Act changed is when you are determining whether an individual meets the definition of disability, you ignore mitigating measures. This means the degree of limitation is considered based on the mitigating measure not being used. As an employer, you may encounter this when you receive a request for a reasonable accommodation. Sometimes a disability is obvious, but when it's not, employers may verify the disability exists. And in this verification, the disability is considered without the use of mitigating measures. I would just like to add that although we ignore the use of mitigating measures to verify a disability exists, we do consider the use of a mitigating measure when we're identifying a reasonable accommodation. And this is because you are not trying to replace the mitigating measure. You are trying to identify an effective solution that enables the employee with a disability to participate in the work-related activity in the presence of the mitigating measure. So the best practice is to first determine the disability exists and then identify the effective reasonable accommodation. And so I'd like to share an example of this in the workplace. An employee with diabetes takes medication during the workday to control blood sugar, and the employee is able to perform the job's essential functions and requests one of two reasonable accommodations. One is to have a flexible schedule to take breaks when needed to take medication, and the other is to be permitted to have food and drink at the workstation to take with medication. So the first step for the employer is to determine whether the employee meets the ADA definition of disability. This is done without consideration of the medication, which is a mitigating measure. In this example, it is determined the employee meets the definition of disability, and so the employee is protected by the ADA and has a right to reasonable accommodation. The effective solutions are considered with the use of the mitigating measure, which is the medication. And the effective reasonable accommodation the employer selected is to modify its policy and permit the employee to have food and drink at the workstation to take with medication as needed during the workday.
So Julie, now that we better understand the definition of disability, let's go back to who is protected under Title I of the ADA. The ADA says the applicant or employee must be qualified. What does qualified mean?
Dennis, being qualified includes two components. First, it means the employee with a disability meets the job requirements, which can include skills, education, certifications, experience, or other job-related requirements the employer has established. It also means the employee is able to perform the job's essential functions with or without a reasonable accommodation. The ADA makes a distinction between essential functions and what are known as marginal functions, and this is important to be aware of. So essential functions are those main tasks the job is created to perform, and marginal functions are those tasks that are shared across employees. An example of an essential function may be to prepare client reports, and an example of a marginal function may be to refill paper in the office printer. And so in this example, to be qualified for this job, an employee with a disability would be required to be able to prepare client reports with or without a reasonable accommodation, but would not be required to be able to refill the paper in the office printer.
So Title I of the ADA references covered entities. Can you talk about which entities have responsibilities under the ADA?
Yes, a covered entity is an entity that must comply with Title I of the ADA, and this includes private employers with 15 or more employees, state and local governments, employment agencies, labor unions, agents of the employer, and joint labor management committees. I'd like to share some examples of what is meant by agents of the employer. So this includes your managers and supervisors, but also outside agencies that you use for services such as staffing or to conduct background or reference checks. During our presentation today, I will be referencing covered entities as employers, since that is the primary audience for this training.
Thank you, Julie. Okay, let's stop and see what questions have come in. And our first question, oops, wrong one. Okay, Julie, is an employer permitted to require documentation to verify a disability exists?
So when an employer receives a request for an accommodation, if the disability itself or the need for the accommodation are not obvious, then the employer is permitted to request documentation to verify the disability exists or to verify the need for the accommodation. The employer is not required to do that, but is permitted to. When the disability is obvious and the need for the accommodation is obvious, that's when you're not permitted to obtain documentation.
Great. Next question. Is an individual who is regarded as having a disability or who has a record of having a disability or who are associated with an individual with a disability qualified to receive reasonable accommodations?
That's a good question, because we said there's three parts to this definition of disability under the ADA, and so some of these parts of the definition also come with the right to a reasonable accommodation, and some it's not appropriate or needed or necessary. And so the answer to that is, if you're regarded as having a disability, no, you wouldn't need an accommodation because you're regarded as having a disability. You don't have a disability. Right. When you have a record of a disability, then you do have the right to a reasonable accommodation, and if it's needed. And so that might include, let's say you have a record of a disability that has been cured or it's in remission, but it may require from time to time a follow-up visit with a doctor. And so permitting that employee maybe a flexible schedule to attend that follow-up visit would be an accommodation. So at times a record of a disability may require a reasonable accommodation. And then the association with an individual with a disability offers you that protection from discrimination. But again, the person who has the association does not have the disability, and so the reasonable accommodation factor does not come into play here either.
Great. And last question. If an employee with a disability doesn't have to be able to perform the marginal functions of the job, does that mean another employee has to do these? And if so, is that fair to the other employee?
The employer is able to look at these marginal functions and look at its team of employees and decide who these can be distributed amongst. And so it's possible that while an individual with a disability as an accommodation may be permitted to not perform certain marginal functions, and yes, those would be absorbed then by another coworker, the individual with a disability is permitted to take on some other marginal functions that he or she is able to perform. And so you can do a swap, per se, of marginal functions so that everybody is still participating in work in a fair way.
Right, that makes a lot of sense. Thanks, Julie. And thanks everyone for your questions. Okay, Julie, we are ready now to discuss employer responsibilities under Title I of the ADA. Now, when you introduced Title I earlier, we learned that the requirements for employers are twofold. One, prohibiting discrimination based on disability in every aspect of employment, and providing reasonable accommodations to qualified applicants and employees with disabilities.
That's correct, Dennis, and the purpose of these two requirements are to ensure qualified applicants and employees with disabilities are not harassed based on disability and have equal opportunity to apply for jobs, be hired, perform jobs, and advance at work, and also have equal access to the privileges of employment. And as you said, Title I covers all aspects of employment. So that covers your hiring process, performing the job, accessing the work environment, and the conditions and benefits of employment.
Okay, Julie, this all makes sense, but I'm wondering, how would an employer know if an applicant or an employee has a disability and to provide a reasonable accommodation?
The general answer to that is you would not know an individual has a disability unless it's obvious, or if the individual chose to disclose the disability to you. The choice to disclose is not mandatory, and it's always the decision of the individual. Also, you generally would not know an applicant or an employee with a disability needs a reasonable accommodation until he or she requests one. Often, employees with disabilities don't need accommodations to perform the job's essential functions, but when one is needed, the employee would have to disclose the disability to request a reasonable accommodation. We are going to talk about reasonable accommodations a bit later in today's presentation, and even more so in the second webinar in our ADA series.
Got it. Thanks, Julie. I know we plan to talk about certain aspects of employment in upcoming trainings in this series, but let's talk about some of these a bit now just to provide a good overview of the kinds of responsibilities that Title I does address. Let's start with the hiring process.
Dennis, the hiring process includes advertising and recruiting for an open position, the application process, the interview, which may include non-medical questions and tests, and making an offer, which may be followed by asking disability-related questions or conducting medical exams. We delivered a webinar in 2020 called Inclusive Hiring that focused on applicants with disabilities. And so to complement our ADA series, we do invite you to access the archived version of that training on our website if you were unable to attend last year. The EEOC has a resource which offers guidance on the hiring process, which they refer to as the pre-employment phase. And so I'd like to highlight a few important aspects from their guidance. The EEOC divides pre-employment into the pre-offer and post-offer phases. And both of these come with guidelines about asking disability-related questions and conducting medical exams. And so here's what the guidance says from a general perspective. When you're in the pre-offer phase, before you extend a conditional job offer, you may not ask disability-related questions or administer medical exams. And this applies to your application forms, job interviews, or any background or reference checks you conduct. Now, in the post-offer phase, which is after the acceptance of a conditional job offer and before employment begins, you may ask disability-related questions and administer medical exams, but this must apply to all candidates who receive a job offer in the same job category. Now, the job offer may be conditioned on the results of these questions and exams, but an employer may not refuse to hire a candidate with a disability based on these results unless the reason for the rejection is job-related and justified by business necessity. And the employer must also show no reasonable accommodation was available to enable the candidate with a disability to perform the job's essential functions. Now, in the employment phase, generally, you can no longer ask disability-related questions or administer medical exams unless it is job-related and consistent with business necessity. And this may occur when you have evidence that a medical condition is contributing to low job performance or causing a direct threat to safety.
Okay, so Julie, an employer cannot ask disability-related questions before a job offer is made. So what kinds of questions can an employer ask during the pre-offer phase?
Remember earlier we said that qualified applicants and employees with disabilities are expected to be able to perform the job's essential functions with or without a reasonable accommodation. And so that is what you are trying to determine in the interview, is whether the applicant is qualified to perform these duties. So during the pre-offer phase, you want to keep the questions focused on the job. This means you may ask the applicant about the ability to perform the job's essential functions, and you may ask all applicants to describe or demonstrate how they would perform these tasks. If you are interviewing an applicant that has an obvious disability or who has disclosed an invisible disability, and you reasonably believe the disability may limit the applicant's ability to perform an essential function, you may ask the applicant to describe or demonstrate how he would perform an essential function, even if other applicants were not asked to do so. The other aspect of hiring I wanted to mention is that all the personal and medical information you obtain during the hiring process that pertains to disability must be kept confidential. And the EEOC does provide guidance for this, which we will talk about a little bit later in today's presentation.
All right, so we've summarized some of the key components of the responsibilities that fall under Title I in regard to the hiring process. Now let's move on to reasonable accommodations. Julie, does Title I require, Julie, what does Title I require of covered employers here?
Well, providing reasonable accommodations is one of the main aspects of Title I. So let's first define what is a reasonable accommodation. This is a change with a job, a work environment, or a work-related process that enables an applicant or an employee with a disability to access the hiring process, perform the essential functions of the job, access the work environment, or enjoy the benefits of employment as effectively as all employees. And this change can come in a variety of forms. The EEOC has organized reasonable accommodations into these main types. So this includes an accessible environment, a job restructure, a flexible schedule, equipment and services, modified policies, and reassignment.
Julie, that's quite a list of options for reasonable accommodations. When should an applicant or an employee with a disability request an accommodation?
Dennis, there isn't one specific time when an individual should make a request. As we mentioned earlier, employees with disabilities often do not need reasonable accommodations at work. But when they do, an employee is permitted to request an accommodation at any point in the hiring process or during employment. And there are many reasons an employee may not need an accommodation initially, but may need one at various times during employment. So for example, an employee with a disability may not need a reasonable accommodation until something changes. And that could be a change with the disability or a change in the work environment. Or an employee may age into a disability or acquire one through an injury. When you do receive a request, the EEOC guidance tells us the employer should act expeditiously, which means very quickly, and then promptly begin the interactive process, which is a collaboration between the employer and the employee with the goal of working together to identify both the need for the accommodation and to identify an effective solution. Figuring out the effective reasonable accommodation is always considered on a case-by-case basis because each employee and each employer and each work environment are unique.
So when an employer is determining the effective reasonable accommodation, are they required to lower standards for quality or productivity?
Dennis, that is a common question we are asked, and the answer is no. Employers are not expected to lower quality or productivity standards. Remember, to receive protection under Title I, the employee with a disability must be qualified to perform the job's essential functions with or without a reasonable accommodation. So the purpose of a reasonable accommodation is to overcome the barrier that is preventing the employee from performing the job and enable the employee to perform the essential functions, which results ultimately in the employee meeting the expectations the employer has set for all employees who perform the same job.
So Julie, let's talk a little bit about undue hardship. How would an employer make this determination between what is reasonable and what causes an undue hardship?
Dennis, an undue hardship is created when an accommodation is too costly or difficult to implement. If an accommodation causes an undue hardship, it isn't reasonable, and the employer is not required then to provide that accommodation. Now, this determination of undue hardship is based on a case-by-case assessment, and the EEOC does provide criteria for employers to consider when they're assessing undue hardship, such as the cost and the nature of the accommodation in relation to the employer's size and financial resources, the nature and structure of the employer's operation, and whether the employer is part of a larger entity.
So when an employer determines an accommodation does cause an undue hardship, is that the end of the request?
No, the next step is to determine if another accommodation exists that is effective and reasonable. So you don't stop considering accommodations because the first one caused an undue hardship. And when the assessment determines an accommodation is too costly, the EEOC does indicate to base this on what the net cost is for the employer after considering any outside funding sources or tax benefits they may be eligible for. If you have identified the net cost and determined there are no other affordable accommodation options, you do want to ask the employee if they want to pay the portion of the accommodation that is deemed an undue hardship. We will be discussing funding sources in more detail in the fourth webinar of this series, and we did address this in a previous webinar that we have archived on our website called Navigating the Reasonable Accommodation Process, if you'd like to access that training.
So Julie, you brought up confidentiality earlier. Let's revisit that topic now. When employers are discussing reasonable accommodation requests with applicants and employees with a disability, these are confidential matters because you are talking about medical and personal information.
That's right, Dennis. The information shared when a disability is disclosed, whether it's a result of a post-offer inquiry or medical exam, or from a request for an accommodation, the information is personal and likely includes medical information, and so it needs to be kept confidential. The EEOC does provide guidance on how to do this, which includes keeping the medical information in separate files and storing these apart from your general personnel files. However, confidential information may be shared under certain circumstances. So, for example, safety professionals may be informed with the necessary information that enables them to implement reasonable accommodations that are being used for emergency situations like sheltering in place or evacuation. And supervisors are permitted to know about the presence of and the use of reasonable accommodation in the work environment. So you can share the information that is needed to properly implement reasonable accommodations in these types of situations, but you're not permitted to share all of the confidential information you have. So for example, a supervisor may be informed that an employee is permitted a flexible schedule, but is not permitted to know this is because the employee is using this break to perform breathing exercises in a private office as a method of managing an anxiety disorder.
Okay, so Julie, let's shift our conversation now to some of the more involved questions we get from employers, such as how to handle low performance when a disability is disclosed and how to address conduct and safety as well.
Well, Dennis, we are focusing on these three topics in our March webinar in more detail, but I do want to share some main points now. Remember earlier we mentioned that for an individual with a disability to receive protection under the ADA, they must be qualified. And that means the individual is able to perform the job's essential functions with or without a reasonable accommodation. So that means an employer can expect all employees performing the same job to be held to the same standards for quality and productivity, including employees with disabilities.
So Julie, what is unique then about low performance and disability?
Well, sometimes low performance is the first indication an employee has that their disability is contributing to their work performance. And because of that, it's not uncommon for an employee with a disability to disclose a disability during a low performance review and sometimes request a reasonable accommodation. So what's important for the employer to know are two things. First, you may apply any consequences that you would apply to any employee with low performance in the same job category. And if a disability is disclosed and a request is made for a reasonable accommodation, one must be considered. And so you would begin the interactive process to identify the need for an accommodation and identify an effective solution.
So what about standards of conduct in the workplace? How do these apply to employees with disabilities?
Well, conduct is similar to performance. Employers can hold all employees, including employees with disabilities, to the same conduct standards that are job-related and consistent with business necessity. Just as with performance, an employee with a disability must be able to meet these standards with or without a reasonable accommodation.
So Julie, what happens if an employee with a disability violates a conduct rule then?
Dennis, the employer would handle the conduct violation the same for all employees, including employees with disabilities, and apply whatever consequences they enforce for the type of violation that occurred. Again, these consequences must apply to all employees who violate the same rule. Now, an employee with a disability may disclose a disability at any point during employment and request reasonable accommodation. And so if the employee chooses to do this as a result of a conduct violation, the employer can do the same thing we just mentioned for low performance. You may apply your consequences as you would for any employee who violated the same conduct rule, and you begin the interactive process to identify an effective reasonable accommodation.
So we've covered performance and conduct at work. What if an employer perceives that a person's disability causes a safety or a health risk at work? Does the ADA address that?
Yes, the term that EEOC guidance uses is direct threat, and it's defined as a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by reasonable accommodation. And a significant risk is considered a high risk, not just a slightly increased risk.
So what should employers know about direct threat and employees, including employees with disabilities?
First, the direct threat standard must be consistently applied to all employees. Now, an employer is not required to hire or continue to employ an individual who poses a direct threat to the safety or health of himself, herself, or others. But the employer must be able to objectively show the applicant or employee poses a direct threat. So just like with undue hardship, we can't determine direct threat based on an opinion or an assumption. It requires an assessment of the employee's ability to safely perform the job's essential functions and a reasonable medical judgment that is based on the most recent medical evidence or the best objective evidence that's available. And the employer must consider whether a reasonable accommodation is available to lessen the risk to an acceptable level. I would encourage employers who may be faced with addressing safety and direct threat to consult the EEOC guidance for more information on how to proceed.
Okay, Julie, that's a great overview of Title I of the ADA for employers. Let's round off today's presentation by sharing with our employer partners what services we have available here at Opportunities for Ohioans with Disabilities to support their efforts in navigating Title I.
Dennis, we provide several services at no cost that are helpful for employers. The first, we offer a variety of educational resources. And so all the webinars we offered in 2020 are archived on our website for you to access on demand. And these include resources such as the Learner's Guide and fact sheets. 2 of these trainings address disability etiquette and navigating the reasonable accommodation process, which was the #1 accessibility resolution submitted from our employers. Also, our 2021 webinars will join this archive as well. After your team views one of our archived trainings, we are happy to host a live Q&A session to answer any specific questions that you may have. Second, our business relations specialists work directly with our employer partners to source qualified candidates with disabilities for open positions. And we do this through direct sourcing of candidates and through hosting virtual hiring events. If you aren't already partnering with us to do that and you would like to, we've included contact information in the Learner's Guide, which includes coverage area by county, so you can easily find the business relations specialist to contact in your area. Of course, Dennis, you are the business relations specialist who works directly with the state of Ohio agencies. And we also have 2 career development specialists who provide support for college students with disabilities who are looking for permanent careers or internships with employer partners. As the worksite accessibility specialist, I provide consultations and deliver training, both of which are customized for employers and address topics such as navigating Title I of the ADA, but also identifying general ideas for reasonable accommodations and providing accessibility guidelines for the physical and digital environments. So if you'd like more information on OOD and all the services we provide for employers, you're welcome to visit our website or reach out to the business relations specialist in your area. And if you are working with an employee who has a disability and may need OOD services, you can reach out directly again to your business relations specialist for assistance, or direct the employee to our online application portal at www.oodworks.com.
Thanks, Julie. That's a great collection of services, and even better that they can all be customized for what each employer needs. Okay, we're going to take one more break to look at what questions we have that have come in, and I just want to apologize in advance. We got a whole bunch of questions that came in, and we're not going to get to all of them today. So, but let's start with the first one. Julie, is the individual having hearing problem considered as disability? Can we hire him or her as a care provider? And do they need any supportive documents?
Thank you for that question. And just to address what Dennis just said, for any questions we don't have time for, we can still get back with you or reach out to Dennis or I. We have our email addresses in the Learner's Guide, so we can get these answered. But the answer to that question is an individual who has a hearing problem. This has a range of different abilities and limitations to it. And so again, you would want to handle this on a case-by-case assessment to determine if this meets the level of disability. And if that's not obvious, then you are permitted to obtain that documentation to identify or verify that the disability exists. As far as whether you can hire him, you base that on whether the individual is qualified for the job, as you would with any candidate that you are interviewing. And so that's how I would approach that.
Great, thanks, Julie. Julie, do you recommend that employees self-identify to their employers in order to have protections in case something comes up in the future?
The decision to disclose a disability is always the decision of the individual with a disability. So that remains their choice, and they can choose to never do that. They can choose to do that in advance, as you're suggesting, to have protection in case something comes up, or they can choose to do that when they need an accommodation. So I don't have a recommendation for that. That is up to the individual.
Great, thanks, Julie. And I think that's all the time we have today for questions. So thank you all for your great questions. I know we didn't get to a number of them. But Julie, I do know you have some final thoughts you'd like to share before we close.
Yes, thank you, Dennis, and thank you all for your interest in today's topic and for being here. We decided to kick off our series of webinars in the Employers ADA Handbook with an overview of Title I because it gives us an understanding of the responsibilities employers have regarding employment and individuals with disabilities. And it also serves as a great foundation for us to talk in more depth about certain topics in our upcoming webinars, such as reasonable accommodations, which is up next in February. All of us here at OOD appreciate your continued interest and our training topics, and even more so your ongoing efforts to make your work environments inclusive for employees with disabilities and accessible for everyone. Please reach out with the questions that you have. We'd like to get those addressed. Again, thank you for being here today. Dennis, always a pleasure to co-present with you. Thank you.